Dear students, good morning. Welcome to another class of jurisprudence. This is going to be a special class because we are going to cover a special topic. We are going to study the case of the 𝐂𝐿𝐴NCIAN explorers. Have you already read the material I have provided? Yes. That's really great to know. For your study, I have provided the material already in the Google Classroom. Today, we are going to study this topic in details. Before I begin, it is important that we review some of the ideas of jurisprudence. I'm sure you have memorized the name of the course already. The name of the course is jurisprudence. What does jurisprudence means? Knowledge of law, but a deeper understanding requires wisdom of law. Perhaps we are trying to be prudent in the understanding of law. So in that order, we have been exploring a fascinating topic by the name of the relationship between... Please speak up, I can't hear you. The relationship between law and morality. Okay, there may be a relationship between law and morality, but what's the problem? Is there any debate among scholars regarding the relationship between law and morality? We have learned about two specific schools of law, which are natural law and positivism. So can anyone tell me, regarding the relationship between law and morality, what does positivism and natural law say? Please.
Positivism is that law and morality does not have any deep connection.
We can't listen to you. Can you speak a little bit louder and speak again?
Yes, sir. Sir, positivity is there is not any deep connection.
There is no connection between
law and morality.
Law and morality.
It's analytical.
Positivism is analytical, always looks into what the law is. Right?
And on the other hand, our naturalism is about the connection between morality and law.
So naturalism claims that morality is an intrinsic
connection
element of law. Okay?
And it's ought to be. অর্থাৎ উচিত বা অনুচিত এটা হচ্ছে আমার naturalism.
It always asks the question of ought. আইন কেমন হওয়া উচিত? They ask this kind of questions. Thank you very much. Everyone, please give her a round of applause. So, in the previous classes, we have been trying to understand the complex relationship between law and morality. If anyone asks you, what is the relationship between law and morality, what would be your answer? Just like one of your friends updating their status in Facebook, it's complicated perhaps, right?
Yes,
to understand this complicated relationship, today we are about to study this case. The name of the case is the case of 𝐂𝐿𝐴NCIAN explorers. Okay? Before I begin deeper into this case, it is important that I tell you this is a fictitious case. What is the word? Fictitious. Are you familiar with this word?
No, sir.
Have you heard about fiction?
Yes, sir.
What is fiction?
Sir, কল্পনা আমাদের হচ্ছে কল্পনা
It is imaginary stories, fictions. What is non-fiction? The documentaries we watch on National Geography, because it is realities, it is not made up. But fiction is always made up, it is story. You know, who is your favorite writer? Perhaps 𝐂𝐿𝐴𝐻 Ahmed. Many of you like 𝐂𝐿𝐴𝐻 Ahmed. The stories of 𝐂𝐿𝐴𝐻 Ahmed is fictitious. It is made up, they are not real. On the other hand, when you read a historical book, perhaps the historical book about Bangladesh, these are based on reality, these are not made up, these are non-fictions. So today we are studying a case that is not a real case. It is a fictitious case. There may be real cases with similar facts, but the judges we are about to study, there are 5 of them. All of them do not exist in reality. None of them exist in reality. But what is the significance of studying such a fictitious case then? We are trying to understand how law and morality can be very complicated to define. This relationship, it's not an easy relationship. Okay? As it is a fictitious case, who has made this story? It is written by whom? Have you found out? the American philosopher and a renowned critic of legal positivism, Lon Fuller. So you have heard about Fuller in the previous class. Today, we will learn about Fuller in more details. So Fuller was a natural law scholar, and Fuller wanted to critique positivism in every state. So he made up this story to help us understand how law and morality, their relationship is complicated. We cannot directly say something very easily on the basis of black letter law. We have to consider so many other things, okay? So now let us dive into the facts of the case. I think all of you like stories.
Yes,
so
sir.
we have a very interesting, perhaps mythical story here, okay? Let me read out a little for you. Once a group of 5 explorers went inside a large cave. 5 explorers, they went inside a large cave. They were members of an organization named 𝐒𝐴𝐵𝐿𝐴𝐿 Society. What is a 𝐒𝐴𝐵𝐿𝐴𝐿 Society? You can imagine this society to be one of your student clubs. Do you know there are many clubs in Uttara University?
Yes, yes.
Perhaps this is an adventure club. They go on trekking, go on mountains and explore different things. Or in other way, you can think of them as researchers. Maybe they have gone to the cave to search for something. That's why the name of the case is 𝐒𝐴𝐵𝐿𝐴𝐿 Explorers. 𝐒𝐴𝐵𝐿𝐴𝐿 is only the name, nothing more than that. Okay? So 5 members went inside a cave. They were members of an organization named 𝐒𝐴𝐵𝐿𝐴𝐿 Society. The cave was made of limestone, chuna pathor. So you understand, limestone is very fragile. It can break very quickly. So it's a very dangerous place to be. They penetrated remote into the cave. They went deep inside the cave. Far from the entrance, meanwhile, a landslide occurred which had completely trapped them inside the cave. My goodness, can you imagine the situation? You have penetrated deep inside a cave and suddenly a landslide occurs and you and 5 of your friends, all of you are trapped. What questions come into your mind? How much food do you have? When are you going to be rescued? Do you have enough support to survive for a few days? All concerns have arisen straight away. The society began their rescue endeavors as soon as they could, but the recurring landslide made it extremely difficult for them. Because they are member of a society, the society got informed. What? Their 5 members are trapped inside a cave. So what do the society do? They started rescue operation immediately. However, because it is made of limestone, recurring landslide makes it very difficult to rescue them. So the rescue operation becomes more delayed. How dangerous is the situation? You can imagine. It was so inaccessible that 10 members of the rescue team had lost their lives. So you can see how dangerous the place is.
Yes, sir.
To rescue 5 members, they have lost 10 members in the rescue operation. This is so dangerous. Okay? However, the explorers were finally rescued on the 32nd day. Dear students, mark this number, 32nd day. They were inside the cave, trapped. Are you curious how did they survive?
Yes, sir.
Human beings should not survive for 32 days. It's already curious. When they were rescued on the 32nd day, it was found that one of the 5 explorers, 5 জনের মধ্যে একজন, Roger Wetmore, were killed by other 4 members. One of the explorer was killed by other 4 members and he was killed to eat his flesh for food and survival. So how did they survive for 32 days?
By eating their own mates, they ate.
By eating the flesh of one of their team members. How dangerous is that? Now you can see the complication. If you kill someone, what is the consequences? You will be punished by death. Now it's a complicated situation, but to rescue these people, 10 people have lost their lives. So what meaning would be there? 10 people losing their life to save 4, and after rescuing them, we hang them to death. 5 জনকে বাঁচানোর জন্য 10 জন মারা গেল, তাদেরকে বের করার পরে আমরা আবার ফাঁসি দিয়ে তাদেরকে মেরে ফেললাম, তাহলে এই 10 জনের মরার কি অর্থ থাকলো? So you understand the complicated situation. Earlier on the 20th day, now let us go back inside. 20তম দিনে, earlier on the 20th day, the trapped group had wirelessly communicated the society and informed that the rations or food they had taken with them were to be exhausted soon. When explorers goes on an adventure, they take a lot of food with them. Have anyone gone to camping? Yes. You have gone to camping? That's amazing. So on camping, people carry even stove with them. They cook their food there, they carry rations, and they survive on the food. So similarly, these Spelunchian explorers, they also had some ration with them. With those food, they survived till the 20th day without any problem. However, on the 20th day, they communicated outside and informed that all our food have been exhausted. We do not have any more food. But without food, can they survive long?
No.
They cannot. From the outside, it was informed that we cannot rescue you for another 10 days. So on the 20th day, they are already aware that before 30th day, we are not going to be rescued. And also asked them, are we going to survive 10 days without food? From the outside, they said, no, you will not survive without food. So now think about the 5 people. They already have the information that we are surely going to die. Now what are we going to do about it? Okay, now let's see what did they do. The explorers asked for medical advice, whether they had any hope to survive the time without any food. They received an answer in the negative. On such outset, এরকম একটা অবস্থায়, Roger Wetmore asked whether they shall survive if one of them is killed and eaten. Wetmore was the team leader. Wetmore himself asked casually, if I kill someone and eat his flesh, will we survive? And from the outside, it was said, yes, they have also taken it casually. So the fallacy, who is the person who died? Roger Wetmore. He is the person is taking the initiative. Wetmore took the initiative and proposed the team members, okay, all of us going to die, but it's better to die one rather than dying all 5. So he proposed, from his bag, he got out some Ludo dice. How fascinating is that? Adventure যাওয়ার সময় Ludo dice কে নিয়ে যায়? But Roger Wetmore found 2 dices and he said, let us play Ludo. And this is only this time the snake will bite you and you will die. So this is real life Ludo they are playing. And Wetmore proposed, let us play Ludo. Whoever loses shall have to die. Everyone hesitated. Everyone surely knows that killing a person is a very bad thing. So no one wanted to do it. But gradually, when they are hungry, they understood rather than dying all 5, it's better that someone be killed. So gradually, all the team members, they agreed, okay, let's agree to play Ludo and let one of us die rather than all 5 of us. But what is the twist? When they started playing it, Wetmore hesitated. Wetmore বলছে, ভাই আমার কেমন কেমন লাগছে, আমি এটা খেলবো না। তাই না? We hesitate a lot because you know that one decision can change your life and you will die. So other team members proposed, তোমার দানটা আমরা দিয়ে দিই। এটা হয়তো বন্ধুদের সাথে খেলতে গেলেও হয়। So the other members played for Wetmore and Wetmore lost. So as a result, it was Roger Wetmore who was killed. And think about it, for another 12 days they were not rescued. On the 32nd day, when they were rescued, it was found that they have committed a murder. It was murder, right? Yes. Killing another person is a murder. The surviving explorers were charged for murder and tried at the court of general instance. The jury chose to leave it to the court to decide whether, under the facts, the defendants were guilty. The court found them guilty of murder and convicted them to be hanged, as the judge could not decide otherwise in the law. So, lower court e jokhon mamlata gelo, আদালত কি করবে? মার্ডার করেছে যখন লোয়ার কোর্ট ফাঁসির রায় দিয়ে দিল, 5 জনের ফাঁসির রায় হয়ে গেল, 4 জনের ফাঁসির রায় হয়ে গেল। বাট there is a problem. Do you think justice has been served here?
No, sir.
Because this is a difficult situation. They did not have any choice. They would die anyway inside the cave. Now they will die by hanging and being punished by the court. So either way they will have to die. So they chose the later on. This case went to the appellate court. Generally this is what happened. Lower court থেকে একটা রায় হলো, যখন মৃত্যুদণ্ড হয়েছে এটা হায়ার কোর্টে যাবে আপিল হিসাবে, এবং হায়ার কোর্ট তখন তার সিদ্ধান্ত প্রদান করবে যে আসলে কি করাটা যায়। Now let us come into the judgment of 5 judges of the higher court. Who are these judges? Are these the judges of the lower court? No, they are the judges of the higher court. That's where, see, the decision is different. Affirmed conviction. That means the appeal court affirms the decision of the lower court. So 2 judges says, okay, he should be punished by death, he should be hanged. The other 2 just said set aside conviction. Setting aside means cancelling, batil kore dewa. So 2 judges took the position, says the conviction is set aside. But there is one last judge. What did he do? Read it out. Read it out. What did this judge do? Withdrawn from decision. The 5th judge or the middle judge, he withdrew from the decision. He said, this is too much stress, I cannot take the decision, I would rather withdraw myself. But the fascinating part is non-Fuller actually takes us on a roller coaster, because 5 of the judges have different rationale. We are trying to study what are the rationale of 5 judges. How did same decision have different rationale? This is the rationale, what is the focal point of our today's study. And that is what we are trying to study in jurisprudence the most. What are the rationale? So let us start with the Chief Justice. What is the name of the Chief Justice?
Truepenny.
Justice Truepenny. So can anyone read out it for me? Okay, please read it out.
Whoever willfully takes another life must be punished by death. The words of the statute do not permit any exception. However, taking 𝐂𝐥𝐬𝐫𝐾 suggestion to pursue the executive branch of the pardon, which in this opinion will accomplish justice without impairing the letter, a spirit of the statute.
Thank you very much. Everyone please give her a clap. So, Chief Justice Truepenny answers in the most positivist way possible. Can you relate? Why is he positivist? Because he is emphasizing on the law. He says, Bangladesh Dondobidhi 302 dhara motabek, whoever willfully takes another's life must be punished by death. কেউ যদি কাউকে হত্যা করে তাকে মৃত্যুদণ্ডই দিতে হবে. The statute, the words of the statute do not permit any exception. The law is very clear here. আইনে বলা আছে এটাই করতে হবে. Do you understand the point? However, he is the Chief Justice. তার মনে তো দয়া মায়া আছে. He is saying that we cannot do any exception. However, if the executive branch pardon them, that is a different case. আমরা এটার দায় নিব না. ঠিক আছে? Have you heard about prerogative of mercy?
No, sir.
রাষ্ট্রপতি কিন্তু ক্ষমা করে দিতে পারে. So, Chief Justice is depending on the executive branch. We will give them death punishment, but let the executive forgive them. It is their decision. We cannot interfere there. So, you see the position of Justice Truepenny, Chief Justice. His position is we cannot do anything else but punish them by death. Clear? Now let's see what Justice Foster did. Who can read it out for me?
Yes, sir.
Please.
The explorers were outside any legal jurisdiction in the cave,
Right.
separated by landside, where they came to a mutual agreement for the act. From another angle, Foster jail defended the killing as an act of self-defense.
Self-defense. Now we are getting to the fascinating territory. Justice Foster set aside the conviction. He is not supporting the conviction. He is rather asking them to go away. They should not be punished. What is his rationale? He said that the explorers were outside any legal jurisdiction. ল্যান্ডস্লাইডের কারণে তারা জমিন থেকে আলাদা হয়ে গেছে, তারা সেপারেট একটা জুরিসডিকশনে অপারেট করছে, তখন এইখানে তারা অপারেট করছে না। Another important part is that they have come to a mutual agreement. Have you started studying the contract law? Not yet. In the next semester you will see. But you understand what is agreement. All 5 members, they had a mutual agreement that let's play Ludo. Whoever loses shall lose his life. So everyone had that in mind. Okay? So there was a mutual agreement for his death. On the other hand, they were sure that they are going to die. On the 20th day, they became clear that we are going to die. So it was an act of self-defense. When you are sure you are going to die, what are you going to do? You will defend yourself. You will try whatever it takes to save yourself. To survive, right? So Justice Foster emphasizes on that survival instinct and says it was rather an act of self-defense and the convicted people should be acquitted. তাদেরকে ছেড়ে দেওয়া উচিত, বেকুসুর খালাস করে দেওয়া উচিত। ঠিক আছে? Do you agree with his rationale?
Yes, sir.
Okay, but we haven't read the other ones. Let's see what Justice 𝐂𝐽 has to say. Okay, let me read it out. The judiciary must consider the long-term implications of setting aside conviction. যেটা আমরা পজিটিভিস্টদের কথা বলছিলাম, একজনকে যদি আমরা সুযোগ দিই, everyone will come here and give excuses. Everyone will say I had this problem so I had to kill him. হ্যাঁ, অমুকের সাথে আমার সমস্যা, এই জন্য মাথায় বাড়ি দিতে হয়েছে। সো এই ধরনের এক্সকিউজ যদি আদালত এন্টারটেইন করতে শুরু করে, তাহলে সমাজে অরাজকতা বেড়ে যাবে। What is the term written here? It may open floodgate and hamper the deterrent effect. We learn 2 important words here, okay? আপনার খাতায় নোট নেন। Floodgate and the other is deterrent effect. What is floodgate? বন্যার বাঁধ। So floodgate will open means বাঁধ ভেঙে যাবে। ঠিক আছে? If we allow one instance to go unpunished, everyone will come and our social order will break apart and crime will begin on the rise. Crime will go on the rise. The other part is law has a deterrent effect. Are you familiar with the word deter? Deter মানে হলো বিরত থাকা। So law has a role to play. যখন আপনি জানবেন যে আইন আছে, আপনি খারাপ কাজ থেকে বিরত থাকবেন, অপরাধ থেকে বিরত থাকবেন। So if you সংযত থাকবেন, deterrent effect. So when there is law in place, you will deter from doing bad things. You will deter from doing crimes. So once you allow one exception, you will see that deterrent effect will lose. Everyone will think that, okay, he got away with a crime, I may also get away with crime. Everyone will start doing more crimes. So Justice 𝐂𝐽 emphasizes on the deterrent effect. It may have bad impact on the society. You see? Now you tell me, do you agree now more with Justice 𝐂𝐽? Yes. So that is the difficulty Lon Fuller places us with. We cannot really agree on one point. As I have told you before, in jurisprudence we cannot think about yes-no answers. Rather, we have to think about the balance, how to understand diverse perspectives. Okay? So now we have 2 more judges left. They are Justice Stating and Justice Handy. Let us read the decision of Justice Handy, who withdrew from the decision. Who can read? Ma'am, can you read it for me, please?
I was
Stating Justice was not convinced.
not convinced to accept the jurisdiction agreement.
Argument
Argument could not be a defense as it could not be valid.
valid.
Self-defense does not apply either as it was a cold-blooded
Act.
act done willfully. Contrary to the death of 10
heroic workmen
workmen
would go in vain
if the explorer die eventually. Therefore, trading J found the
case indecisive. দেখেন, he is actually rebutting the decision of Justice Foster. You all agreed with Foster. Now, Justice Tatting will come after you. Tatting firstly says he was not convinced that jurisdiction argument, landslide হয়েছে তো কি হয়েছে, তারা তো দেশের মধ্যেই আছে, jurisdiction অবশ্যই আছে, সেখানে যা খুশি তাই তারা করতে পারবে না। সেকেন্ড পয়েন্ট হচ্ছে, he said there was a mutual agreement. However, mutual agreement cannot be for illegal things. আপনি কারো জীবন নেওয়ার জন্য কন্ট্রাক্ট করতে পারেন, কারো জান নিয়ে তো কন্ট্রাক্ট করা যায় না। সো মিউচুয়াল এগ্রিমেন্টটাও ইলিগাল জিনিস নিয়ে কন্ট্রাক্ট করা যায় না। যেমন আপনি যদি মাদক নিয়ে কন্ট্রাক্ট করেন, মাদক তো একটা ইলিগাল সাবস্ট্যান্স, সো ওই জায়গায় উনি রিভার্ট করছে যে এগ্রিমেন্টের আর্গুমেন্টটাও এখানে গ্রহণ করা যাচ্ছে না। দ্য থার্ড অ্যান্ড মোস্ট ইম্পর্টেন্ট পার্ট ইজ সেলফ ডিফেন্স। Can you really claim it self-defense? You all agreed, okay, they knew they are going to die, so it was self-defense. But self-defense comes from imminent threat. কেউ আপনার মাথায় বাড়ি দিতে আসছে, আপনি ওটা আত্মরক্ষার জন্য করে দিয়েছেন। কিন্তু এইখানে কি আসলে ওরকম স্পন্টেনিয়াস ঘটনা ঘটেছে? না, ইট ওয়াজ রাদার কোল্ড ব্লাডেড। সবাই ঠান্ডা মাথায় চিন্তা করে পরিকল্পনা করে হত্যা করেছে। ইট ক্যান নট বি ক্লেমড অ্যাজ সেলফ ডিফেন্স। সেলফ ডিফেন্সের একটা গুরুত্বপূর্ণ এলিমেন্ট হচ্ছে এমিনেন্ট থ্রেট থাকবে এবং আপনি কোনো কিছু না ভেবে ওইটার একটা রিয়াকশনে তাকে মেরে দিয়েছেন। সেলফ ডিফেন্স তখন আর্গু করা যায়, কিন্তু এখানে তো অনেক চিন্তা ভাবনা করে করা হয়েছে। সো দিস ক্যান নট বি ক্লেমড অ্যাজ সেলফ ডিফেন্স আইদার। সো জাস্টিস স্ট্যাটিং সো ফার হোয়াট এভার হি হ্যাজ আর্গুড, দেন ইউ আর ইন সাপোর্ট অফ কনভিকশন। এটা মনে হচ্ছে না যে তাহলে তো তাহলে ফাঁসি দেন, তাহলে ফাঁসি দিতে অসুবিধা কোথায়? কিন্তু হি ইজ সেইং ইফ আই গো ফর কনভিকশন দেন দ্য ডেথ অফ 10 হিরোইক ওয়ার্কম্যান, 10 জন তাদেরকে যে উদ্ধার করতে গিয়ে জান দিল, এই মানুষদের জীবনটা তো তাহলে বৃথা চলে গেল। যে পয়েন্টটা আমরা একবার অলরেডি বলছিলাম, যে যাদেরকে উদ্ধার করতে এত লোক মারা গেল, উদ্ধার করে তাদেরকে আপনি আবার মেরে ফেললেন। সো তাহলে অর্থটা কি থাকলো? সো জাস্টিস স্ট্যাটিং দ্যাটস ওয়াই হি সেইজ দ্য হিরোইক ওয়ার্কম্যান death would go in vain, tara brithai jabe. That's why this case is indecisive, and he says I cannot give a decision, I withdraw from this case. Perhaps this is the point Fuller is trying to make in this case. The black letter law only talks about the rules that whoever willfully kills shall be punished by death. কাউকে হত্যা করলে তার শাস্তি হবে মৃত্যুদণ্ড। আইন শুধু এটাই বলে, কিন্তু আইনের কি এত লেয়ার্ড পার্সপেক্টিভ সম্পর্কে জানা সম্ভব? না। যখন রিয়েল লাইফে একটা ঘটনা আমরা স্টাডি করতে যাব, তখন এরকম বিভিন্ন লেয়ার থাকবে, এইটার একটা ডিসিশনে আসাটা সহজ নয়। ওই পয়েন্টটাই এখানে ফুলার মেক করার চেষ্টা করছে। ঠিক আছে, উই হ্যাভ ওয়ান মোর জাস্টিস লেফট টু স্টাডি। উড ইউ রিড ইট আউট ফর মি? জাস্টিস হ্যান্ডি? Yeah. Okay, who else? Who else? Please.
Handy J found the issue to be a practical wisdom and emphasized on public opinion.
Right. 90%
of wanted the Supreme Court to pardon or let off the explorers with a small punishment. He argued this conclusion can be reached from general
conscience.
Conscience where the abstract rules fail to lead.
Thank you very much. Once again, another clap. We have another important point here. Public opinion. Let me erase some of the writings. I am writing them again to emphasize on this word. What is public opinion? Right. Why is it important? Why is it important to consider the will of the people? Have you heard this word before? Will of the people? Why did you hear it? In the Constitution, সংবিধানের 7 অনুচ্ছেদ বলে জনগণ সকল ক্ষমতার উৎস। So even in judiciary, যদিও আমরা বলবো পজিটিভিস্ট জাজরা কখনোই এটা এন্টারটেইন করবে না, কিন্তু জাস্টিস হ্যান্ডি এমফাসাইজড অন পাবলিক ওপিনিয়ন। ফ্যাক্টে একটা অংশ মিসিং গেছে। ওইখানকার কোনো একটা পত্রিকা, চিন্তা করেন, মনে করেন দ্বিতীয় আলো, তারা একটা জনমত জরিপ হোল্ড করেছে। বাংলাটা হচ্ছে জনমত জরিপ। public opinion. From that public opinion, they found out 90% of the people there, they wanted them not to lead করতে দেবে না, কিন্তু জনগণের মতামত কিন্তু আমাদেরকে সুন্দর একটা সমাধানের দিকে নিয়ে যাচ্ছে. You see the fascinating part? Now which one do you agree the most?
Justice handy.
Justice handy? You are changing your decision so randomly. Every time I talk about one judge, you get on board with his support. However, in conclusion, we can say one thing. The purpose of studying this judgment is about learning different perspectives. But before I get into the conclusion, let me ask, do you have any question? Yes, please.
আমার কোশ্চেনটা হচ্ছে যে লাস্টে মতামত হচ্ছে জাস্টিস হ্যান্ডি স্যার ওনার how is the decision of justice handy related to morality?
How is the decision of Justice Handy related to morality? Good question, thank you. You see, we are emphasizing on public opinion. Where does the opinion of the public come from? It comes from individual persons, and individual persons are deciding from the perspective of his morality. When I am participating in the public opinion, জনমত জরিপে যখন আমি ভোটটা দিচ্ছি, তখন আমার মোরালিটি, আমার বিবেক থেকে আমি চিন্তা করছি যে আসলে এই লোকের ফাঁসি হওয়া উচিত কিনা. সো সেখানে কিন্তু জনমত জরিপের যেই রায়টা, এটাও কিন্তু একটা মোরালিটির রিফ্লেকশন. ইট ইজ নট দ্য রিফ্লেকশন অফ ব্ল্যাক লেটার ল. In that way, you can think that the two judges, they were very positivist, and the other two judges, they were trying to argue from the perspective of natural law or morality. Okay, thank you for your question. A round of applause for him. Okay, now let us come to conclusion. What did we learn from here? Okay, jurisprudence is about teaching you different perspectives about law. In jurisprudence, we do not get to decisions quickly. Rather, when you are a lawyer, when you are a judge, you cannot be biased. Okay, this happened, this is the conclusion, eta amar rai diye dilam. No. Rather, you have to listen to both parties, and then you have to wait which part is heavier.
আপনার কথা মতো আমরা বলতে পারি যে এখানে আমাদের 5টা জাজমেন্ট দেওয়া আছে 5 ডিফারেন্ট জাজেস.
Right.
এটা ফিকশনাল বাট ইটস আ জাজমেন্ট, তাই না? তো স্যার আমরা একটা জাজমেন্ট শুনে এক ধরনের একটা মানুষকে সাপোর্ট করি. তো স্যার আমাদের জুরিসপ্রুডেন্সের অনুযায়ী আমাদের ফার্স্ট উচিত হচ্ছে সবার মতামত একসাথে শুনে বুঝে অ্যানালাইজ করে দেন আমাদের মতামত.
Absolutely. Thank you very much. Perhaps you have got the summary of the class very quickly. Let me emphasize on another term. When judges explain their decision, every judge has given different rationale. I have told you before, this rationale word is very different from logic, explanation, or reasoning. Why is it different? How do you break the word rationale? If we break this word, we will find the word ratio. What is ratio? Onupat. So while judging a case, the judge actually thinks about the ratio. অনুপাতিকভাবে উনি চিন্তা করে দেখে যে কোন পক্ষের রায়টা আসলে বেশি যৌক্তিক, এবং যেই দিকে ওয়েটটা বেশি সেই অনুপাতে উনি ওনার ডিসিশনটা নেয়. সো অলওয়েজ থিঙ্ক ইন র্যাশনালে রাদার দ্যান টেকিং ইউর ডিসিশন ভেরি কুইকলি. আমাদেরকে আনুপাতিকভাবে চিন্তা করতে হবে, রেশিও চিন্তা করতে হবে, সকল দিক বিবেচনা করে, রাইট? নাও ডিয়ার স্টুডেন্টস, I have a fun exercise. Before that, let me show you the original paper of Lon Fuller. This is a whole book written on Lon Fuller's explanation. And the first part is the original writing of Lon Fuller, the one I have marked here. Okay? So I thought it will be very difficult for you to read, so I liquidified them in 2 pages. But if you are interested, I suggest you please go through the original writing of Lon Fuller. Okay? Every judge, প্রত্যেক জাজের জাজমেন্ট কিন্তু মাত্র ওই একটা বক্স না, এই বিশাল বিশাল জাজমেন্ট এখানে আছে, সেইটাকে ছোট করে সামারাইজ করে আমি আপনাদের জন্য নিয়ে আসছি, ঠিক আছে? So if you want to read, I have marked and highlighted here, so you will see the points very quickly. Okay? So the case we have studied so far, it is a fictitious case, right? But is there any real case with similar facts? There is one. Right now you can see in the screen, the name of the case is the Queen versus Dudley and Stevens. This is a real case from 1884. Okay? And the facts of this case are very similar, but I will not tell you the facts. I will give you 5 minutes. I've already provided this material in your WhatsApp, but you don't have to be confined within that material only. You can go on internet, you can use Wikipedia, and after 5 minutes you have to tell me what was the facts and the decision of this case. Okay? So everyone hurry up, you have only 5 minutes. So dear students, the 5 minutes are over, and now we will listen to some of you who have found out the judgment of this case.
So the case is about the Queens versus the Dudley and Stephens. And the key facts of the case is, in July 1884, 4 crew members, which are Tom Dudley, Edwin Stephens, Edmund Brooks, and Richard Parker, were stranded in a lifeboat, and after 19 days with no food and no water, Dudley and Stephens killed the cabin boy.
Right. So dear students, do you find the similarity?
Yes, sir.
On a lifeboat, 3 people were stranded, and they killed the cabin boy. After 19 days, they were rescued, right? So they killed the cabin boy named Richard Parker.
Yes, sir.
Richard Parker, he is perhaps inspired the Richard Parker in Life of Pi. আপনারা Life of Pi মুভিটা দেখেছেন? Life of Pi মুভিতে যে রিচার্ড পার্কার নামটা ইউজ হয়, প্রবাবলি এই কেসের যে রিচার্ড পার্কার তার থেকে ইন্সপায়ার্ড হয়। ওকে?
And the thing is that who was near to death? Richard Parker.
একটা আর্গুমেন্ট হচ্ছে রিচার্ড পার্কার এমনিতেও খুব অসুস্থ ছিল, সমুদ্রের পানি খেয়ে, এবং সে হয়তো মারা যাওয়ার মতো একটা পরিস্থিতি তৈরি হয়েছিল।
And তার থেকে বড় কথা হচ্ছে যে ওনার মৃত্যুর ঠিক 4 দিন পরে যখন ওনাকে রেস্কিউ করা হয়, ওনার মৃত্যুর 4 দিন পরে যখন ওনাকে রেস্কিউ করা হয়, they found the body fleshes over the boat, so they decided they killed a cold-blooded murder.
Right. So we get the fact from him quite similar to Spelunkian explorer. Now, can anyone have identified the judgment? Fiha, have you? Anyone? Positivist perspective থেকে judgment কি হওয়া উচিত?
For positivist perspective থেকে যদি judgment করা হয়, তাহলে judgment হবে যে they don't have any food, they don't have any water, and they don't have any choice. So for their own life, they killed a man who was near to them.
Yeah, but it's positivist I'm telling about, not naturalist.
It's about murder. They murdered.
They murdered a person, and the law says if you murder someone, you have to be punished by death, and that is what exactly the court did in this case. The court convicted them, quite similar to Spelunkian explorer. ঠিক আছে? একটা পয়েন্ট আমি মিস করেছি, Spelunkian explorer-এও কিন্তু আদালত যখন দুয়ে দুয়ে বিভক্ত, তখন আনসারটা কি হবে আসলে? চিফ জাস্টিস যে রায়টা দিয়েছেন এটাই বহাল থাকবে। সো যদিও দেখে মনে হচ্ছে দুয়ে দুয়ে এটা সমান আছে, কিন্তু চিফ জাস্টিস যেহেতু কনভিকশন অ্যাফার্ম করেছেন, তাহলে ওদেরও কিন্তু ফাঁসির রায়টাই বহাল থাকলো। কার্যকর হয়েছে কিনা সেটা পরের কথা। সেই আনসারটা আমরা পাবো এই কুইন ভার্সেস ডাডলি অ্যান্ড স্টিভেন্স। সো রাদার দ্যান আস্কিং ইউ এনি মোর, লেট মি গেট টু কনক্লুশন। এই কেসটা সিমিলার ছিল, কিন্তু আলটিমেটলি আদালত তাদেরকে কনভিকশন দিলেও the executive pardoned them. Executive means the crown. The crown had some prerogative power to mercy someone, and ultimately the crown 6 months imprisonment তাদেরকে দেয়া হয়েছিল। হ্যাঁ, সো অনেকটা কিন্তু জাস্টিস হ্যান্ডি যে পাবলিক ওপিনিয়নটা নিয়ে কথা বললো, যে অল্প শাস্তি দিয়ে তাদেরকে ছেড়ে দেওয়া উচিত, তাদেরকে ফাঁসি দেওয়া উচিত না, এই মামলায় কিন্তু সেই ধরনের একটা রায় হয়েছে।
Ruling the High Court of Justice ruled that necessity does not justify murder.
Right.
Concluding that the temptation to save one's life and one's life is not legal excuse for taking another.
Exactly. So পজিটিভিস্টরা যেভাবে আর্গু করবে, ওরা বলছিল যে নেসেসিটি ছিল ওইখানে, আমরা মরে যেতাম, from necessity we killed a person, but necessity is not a defense to kill another person. আদালত সেটাই বলছে। সো আদালত তাদেরকে ঠিকই রায়টা দিল, শাস্তির কনভিক্টেড করলো, কিন্তু ক্রাউন তার মার্সির যে পাওয়ার আছে সেইটা ব্যবহার করে তাদেরকে 6 মাসের কারাদণ্ড দিয়ে ছেড়ে দিল। সো দিস ইজ দ্য রিয়েল কেস, রিয়েল লাইফে এইটা হয়েছে। ঠিক আছে? So dear students, when you study the case of the Spelunkian explorer, you also relate the case of Queen versus Dudley and Stevens. Okay? Can anyone summarize what did we learn from this case or today's class?
So we have learned a very important thing from the class. And the thing is, মানুষের প্রয়োজনের সাথে মৃত্যুর কোনো সম্পর্ক নেই। মানুষের প্রয়োজন থাকতেই পারে, বাট ওটার সাপেক্ষে আমরা কারো হত্যা বা কারো জীবন নিয়ে আমরা তাদেরকে কোল্ড ব্লাডেড মার্ডারের সম্মুখীন ফেলতে পারবো না।
Yeah, exactly, very much correct. On the other perspective, from a jurisprudential perspective, not every case is going to be murder case, but in every case we will have different facts, different perspectives. So as law students, as lawyers and judges, we must consider all the perspectives. Have you seen Infinity War of Avengers? One of our favorite movies. There is a scene where Doctor Strange sits like this and calculates thousands of possibilities. Perhaps as lawyers and judges, you also have that important calculation to do. You have to see through commoners and see various perspectives, and then when you decide, it must be on the basis of the rationale. You have to weigh on which side the law or the decision should go, right? So on that note, dear students, I am concluding today's class.
Thank you, sir.
Can I have a clap for that? Okay, thank you.